every single thing that we believe is a right that people should have should be codified into law. Nuance is 100% required for these conversations. It's a dumpster fire, honestly. Reproductive rights and the state of politics in the United States is a dumpster fire. So today we are going to be talking about Ohio voting on November 7th to codify access to reproductive health care and choice into their constitution. We're going to go over what Issue 1 says, why you should vote yes on it if you are in Ohio, and why this should matter to you even if you are not in Ohio. If you are new, please subscribe. We'd love to have you. Subscribe here, second channel if you want, because over there we post stream clips from the Twitch stream, and you could also come to the Twitch streams. They are very fun, and you should be here with us talking about things live, because then you can ask questions. Part of the reason we're talking about this and why this is important is because there is a lot of misinformation around this, and that is the case with any law that attempts to restrict or codify reproductive access and choice into constitutions. There will always be misinformation, and most of that is going to be targeted, purposeful misinformation that people are trying to push forth because they have a narrative that they want to push that's not true. All right, so abortion access, let's talk about Ohio. Main takeaway of what we're talking about today should be that codifying the right to access pregnancy termination is on the ballot in Ohio. And if you're an Ohio voter, you should be voting yes on Issue 1. What does that mean? Voting yes on Issue 1 codifies into the Ohio Constitution the right to access reproductive choice and pregnancy termination. The codifying of a right into a constitution basically means that it's a right that's written into the Constitution that says this is a right that can't be taken away in the state of Ohio. Meaning, they can't pass a federal abortion ban and supersede the state's right to constitutionally guarantee access to termination in that state. I am certain there are legal workarounds to this, but the reason that this is important is because of the possibility of a federal ban at some point. Does this matter if you are not in Ohio? I think it should absolutely matter if you're not in Ohio. And the reason is because codifying your rights into constitutions, in state constitutions, is the only way that we can circumvent the overreach that's currently being experienced. And I used to be at a place where I thought, there's no way that they could overturn Roe v. Wade. And after Dobbs, I am now at a point where I'm like, anything could happen. And every single thing that we believe is a right that people should have should be codified into law. There was a point in the Obama administration where they had the opportunity and probably could have gotten the votes to codify access to reproductive health care and choice into the federal constitution of the US. And they did not do that because it was not a priority. It's a dumpster fire, honestly. Reproductive rights and the state of politics in the United States is a dumpster fire. All right, what else matters if you're not in Ohio? Well, we need to know what to push for elsewhere. We need to know what that looks like, what the advocacy looks like, what the learning points are, and why it matters. And as someone has already mentioned, the misinformation is a massive issue, as it always is. The first thing that somebody hears is what they're going to believe most solidly. And you have to do a lot more work to undo that misinformation than you do to prevent it. So background on this, April 2019, Ohio State Legislature put forth a law to ban abortion starting at 6 weeks, and that passed. At the time, Roe v. Wade was still in place, meaning there was a federal protection on access to termination, and the gestational age in which that access was federally protected varied across the time that Roe v. Wade was in place, but I believe at this point in 2019, it was like maybe 15 or 18 weeks. I can't remember. I have a video about it if you want to go watch it. So in 2019, an injunction was filed against that, and then the injunction was upheld that yes, this is not able to actually be a law in Ohio because the federal law prevents it. So, whatever, we can't do it. But the law still stood there, right? So that means if Roe v. Wade is ever overturned, it could immediately go into place. And Texas had the same thing where if Roe v. Wade was ever overturned, immediately these incredibly restrictive laws would go into place. Okay, so June 2022, we all know what happened. Dobbs' decision, Roe v. Wade protections were overnight erased. And the Ohio Attorney General filed a request that the 2019 injunction be dissolved, meaning that that law would go into place. and Ohio became one of the most restrictive states for abortion access, along with my home state of Texas. In 2022, October, a reproductive rights coalition filed a suit to challenge that 6-week ban, and the new injunction against the 6-week ban was actually put into place. And so from June to October, there were really significant restrictions on abortion access in Ohio, but starting in October, when that injunction was agreed upon by whoever they filed it with, the access was reinstated up to 22 weeks in Ohio. So this was a big win and is indicative of a larger kind of attitude towards abortion that we've seen since the overturn of Roe v. Wade, which we'll talk about in just a minute. In September of 2023, so last month, the Ohio State Supreme Court heard arguments that were appealing that injunction. So it's been just under a year since they reinstated access, and the Supreme Court of Ohio is hearing people talk about why they should actually reinstate that 6-week ban. There's been no ruling at this time. It could happen whenever. November 7th, 2023 is the last day to vote in Ohio. And on the ballot is issue 1, which would codify the right to access reproductive choice in Ohio. And the misinformation surrounding this is the reason that I'm phrasing it this way. But if you are a voter in Ohio, you should be voting yes on issue 1 if you want to ensure that reproductive health care is codified and access is guaranteed according to the Constitution of Ohio. Let's talk about this guy. This is Dave Yost. He is the Ohio Attorney General who filed for the 6-week ban to go into place immediately following the Dobbs decision. He is one of many extreme conservatives who you might remember from this case of a 10-year-old who was looking to get an abortion in Indiana after she had been sexually assaulted, obviously. He publicly denied the existence of her, said no, this is just a fabrication that was made up. So we'll go to his page on Wikipedia where it talks about this. So on June 30th, 2022, shortly after the ban became effective, a 10-year-old rape victim who was 6 weeks and 3 days pregnant, I don't know why that's in quotations, pregnant, traveled from the Columbus area to Indianapolis, Indiana to get an abortion and avoid carrying her rapist child. The incident was widely reported, beginning with an article in the Indianapolis Star on July 1st and was mentioned by President Biden on July 8th. July 11th, Yost disputed the report, saying that neither his office or the state crime lab had any information on the matter and that his staff had heard, quote, not a whisper about it. In an interview on July 12th, Yost said it was more than likely a fabrication. That day, the report was actually confirmed by the police in Columbus and a rape suspect was arrested. Because of that, Yost had to walk back the words that had come out of his stupid mouth. And he said, oh, well, actually, okay, the exceptions to the 6-week ban would say that this 10-year-old would have been able to obtain a legal abortion in Ohio, which is not true. And the Ohio Legislative Commissioner came forth and said that nothing in the language of the bill would explicitly include the age of the person seeking an abortion as a qualification reason for an exception. And there are no, to my knowledge, certainly not at the time, and to my knowledge even now, there are no laws in place that have the age of the person seeking termination included as a reason that they would be able to access it. Now, why is threat to the life of the person who's pregnant and pregnancies conceived from rape not good enough as exceptions? Well, one, I think termination should be accessible even to people who don't fall in those categories. And I also find it weird if you truly think that this is a life that is being murdered, that you would make those exceptions, because it doesn't add up. It's not consistent in my head. Regardless, I think that the life of the mother exception or the life of the pregnant person exception is not good enough, because we've talked about before, when does that become an acceptable level of risk? Okay. I think I have a clip from Instagram that goes over this succinctly. You have fallen victim to the propaganda. Having exemptions for a life-threatening emergency is not enough. People will die, because when does your life become in danger? Life is always at risk in pregnancy, more so than when you are not pregnant. So at what point, how dead must my patient be, must your daughter be, must your sister be before the doctor can act? What percentage of near death do we need before we can do our job without getting criminal charges filed against us? Where is the line? You can't tell me because we don't know, and that is why these things are dangerous. Okay, so does that make sense? That's why risk of death is not an appropriate way to make legislation. The rape one is because how many people are actually tried and convicted of rape before you would be out of the time frame where an abortion was an option, right? So you're going to run into situations here of, if that is an exception, people are going to be required to prove that that is the case, right? And how do you prove it? I mean, most sexual assaults are not reported for lots of reasons. And even of the ones that are, most are not actually convicted. And of the ones that are, none of those happen in a time frame where you would still be able to access termination. So there are so many things that would go into how that actually would be used. And I just don't think that that is sufficient, and it would be almost impossible to make that an exception that actually made any difference, if that makes sense. So what is the issue 1 amendment? I'm not going to go through the whole text, but I will briefly show you here what is in the summary. Basically, amendment provides an amendment to Article 1 of the Ohio Constitution and says that adding Section 22, which would be the right to reproductive freedom with protections for health and safety. It would say that 1, every individual has a right to make and carry out one's own reproductive decisions, including but not limited to decisions on contraception, fertility treatment, continuing one's own pregnancy, miscarriage care, and abortion. Now, this is important even for more reasons than just codifying the right to termination access, right? Because a federal ban on abortion might be at some point down the line. That would not shock me, honestly, at this point in my life. But what also would not shock me is furthering restrictions on access to contraception, on access to IVF, because storing embryos in labs, if you're not allowing an abortion to happen at 4 weeks into the pregnancy, is obviously going to be a problem. So all of these things are important for more than just access to abortion. This is why, even if abortion access is not that important to you, there probably is something in this list that is important to you. It's not just termination. State shall not directly or indirectly burden, penalize, prohibit, interfere with, discriminate against either an individual's voluntary exercising of this right or a person or entity that assists in an individual exercising this right, unless the state demonstrates that it is using the least restrictive means to advance the individual's health in accordance with widely accepted and evidence-based standards of care. What this is saying is that they cannot prosecute you for aiding and abetting abortion, things like that. These are things we've seen states trying to enact into law. In Texas, we've seen this of trying to get things passed that would mean you can't fly out of state or drive out of state. Someone can't drive you out of state to have a termination. That's what that's addressing. However, abortion may be prohibited after fetal viability, but in no case may such an abortion be prohibited if, in the professional judgment of the pregnant patient's treating physician, it is necessary to protect the pregnant patient's life or health. I have no problem with that. My mind is very open, I like to get information and change my beliefs if something warrants that, but I think that this is a reasonable inclusion. I know there are some people who disagree with me on that, some people who don't think viability as a cutoff is reasonable. I don't know. As used in this section, fetal viability means the point in pregnancy when, in the professional judgment of the pregnant patient's treating physician, the fetus has a significant likelihood of survival outside the uterus with reasonable measure. This is determined on a case-by-case basis, and state includes any governmental entity and political subdivision. So what they're saying there is that they're not going to set a gestational age limit where it becomes a viable pregnancy, meaning sustained life outside the womb. And because this is a contentious topic, obviously, and the reason that it's contentious, in my opinion, is because this varies. 1, gestational ages are not always super accurate. Birth weight is probably a bit more predictable. But also, intensive measures to save a baby born at 22 or 23 weeks are really reasonable if the parents want to do that. But these are very, very expensive. They are very like in the hospital is very long, and outcomes are not great. Plus, they are painful and oftentimes inclusive of long-term problems that come from them. So employing Hail Mary life-saving attempts is something that I don't think people should be told they can't have at a periviable gestational age. Meaning, if someone's baby's going to be born at 500 grams, 22 weeks. I don't think that if they're in a facility with the capability to employ that type of work, that it should be told that they can't pursue that. But I also don't think that it should be said that they have to, because that is a very personal decision. And having cared for patients who have been in that scenario and who have gone on both routes, I have seen it. I've seen it both ways. And I cannot imagine a world where we make people choose the way that we are telling them they have to at a peri-viable age. So the reason I'm aware of this is actually because the League of Women Voters reached out to me and they sent some information about this and asked if I would talk about it. They didn't pay me. This is not sponsored, but it is important to me. And I think that's probably one reason that they reached out and told me. They have a lot of really great information available, and they hosted a webinar on issue 1 that had interviews with a couple of experts, including Maria Gallo, I don't know if, I'm sorry, I don't know, who's a PhD. She's a sexual and reproductive health epidemiologist, and she teaches as a professor at OSU College of Public Health. And Jonathan Enton is an attorney, and he is a professor of constitutional law at the Case Western University School of Law. So these are both incredibly well-equipped individuals to be discussing this. So how is this different from Roe v. Wade? This is some information from the League of Women Voters.
Access would likely be quite similar because issue 1 embodies a very strong reproductive right, and it imposes a pretty substantial burden of justification on the state if it wants to limit that right.
So yeah, it basically prevents the state from being able to impose restrictions. Obviously, there are times where that could probably be overridden, but codifying these rights is really important first step in making these changes.
The federal constitution protects access to contraception at this point.
So did you hear what he said? At this point. So the reason it's important to include contraception in these things is because it is well within the realm of possibility that the U.S. federal constitution will not always protect that.
In the Dobbs case, Justice Thomas wrote a separate opinion saying that he would overrule the cases that protect access to contraception. And at least one member of the General Assembly has introduced a bill that would outlaw at least some forms of contraception.
All right, they're going to address viability. And as I've already said, this is a gray area.
So, and we can think of it as 2 different ways. At the beginning of a pregnancy, we say the pregnancy is viable, meaning at early during the pregnancy, there might be things that have happened that the pregnancy just won't continue. It's not possible to continue this pregnancy. These things are relatively more clear cut. The pregnancy won't continue. It could be dangerous to continue. If you have an ectopic pregnancy, you may very well need to have life-saving treatment for it.
Well, I would take issue a little bit with that wording because all pregnancies are dangerous to continue. Like, it is always inherently more dangerous to be pregnant than not to be pregnant. So all dangerous all the time. That doesn't mean most have bad outcomes or that terrible things happen to everybody, but it is always more dangerous to be pregnant than to not be pregnant. What she's saying here is that there's some that are clear cut because they never result in a viable pregnancy outside of like some incredibly fringe exceptions that are absolutely not the rule, okay? So ectopic pregnancy, 99.9% of the time is going to result in a not viable gestation and has a very high rate of very serious complication. So these are like things that have almost no chance of viable pregnancy, baby being born, take home baby with you, and which also carry a significant risk of harm. And then they're going to talk about what is viability? Well, the rest of the definition of viability is incredibly gray, right? Because we were just talking about how gestational age is not exact, birth weight is more predictable, but you don't know birth weight exactly until the time of birth. You can guess at it on an ultrasound. And then you also have to take into account like what the hospital is set up for. I can't have a NICU that can take care of the tiniest baby ever born and attempted to keep alive at every place that a baby is born. So viability has to, by definition, vary based on the availability of healthcare tools and people who can assist. So you can't put a gestational age for viability into law because it's going to vary in places. And like I was just telling you earlier, forcing people down one of these routes when they don't want to go down that route is, in my opinion, not ethical. People who listen to this kind of stuff and talk about it, especially people who are not interested in having a genuine conversation, will say 23 weeks is viability, or 22 weeks, or 22 and 5, or 24 and 5, or, they will tell you all of these things. And the truth is that none of that is viability, because viability is a percentage, and all they're talking about is that, all right, this is the youngest gestational age or birth weight that has ever resulted in a baby that was born and lived to go home. And that progresses on a spectrum that gets fairly close to 100%, right? So all you're talking about with viability is what's the youngest gestation age we've ever been able to intervene and safely get home, and what's the point where 99% of babies will be able to live on their own outside of a uterus. And that happens from about 22-ish weeks. Again, not an exact science, because measuring gestational age is not an exact science. And the size of the baby is significantly impactful here, because the birth weight being less than 500 grams makes it much harder to intubate, meaning to put a breathing tube in. And that just progresses along a spectrum until you reach a gestational age where almost all babies will be able to survive outside the womb. So that question, because it cannot be answered in a single word, is something that people argue about on the internet a lot, and really annoys me, because people aren't willing to have these conversations with nuance, and nuance is 100% required for these conversations. Late-term abortion is a political word. This is not something that is medically defined. And what you will see when people say late-term abortion is that they sometimes mean over 20 weeks. They sometimes mean after viability, which we already discussed the problems with that. And they will sometimes mean third trimester, after 28 weeks or after 29 weeks. And they sometimes will mean like birth, right? Okay. And that's a problem, because when you have words that don't have definitions, when people start talking about it, it can feel very confusing and sometimes even alarmist, because you're not really sure like what is happening or what are we arguing about. And maybe I don't think that people should be able to have abortions in the third trimester. But when you say late term, maybe the person on the other side who's saying, I do think they should be able to have late term abortions, maybe they mean after 20 weeks. So that's a problem. And we have to stop using this language that doesn't have a definition. And I think what you all can do on your side is to hold people to the fire if they're using this language and say, what do you consider a late term abortion? Tell me what you mean when you say that. Define it. You must define what you mean, because otherwise this is a meaningless discussion. All right. So what is late-term abortion? And let's talk a little bit about what that can mean. All right. So sometimes people mean after 20 weeks. 1.3% of abortions were performed over 21 weeks in 2013. So around 1 to 1.5% of abortions in the United States happened after 21 weeks. So when someone says later term abortion, they could be referring to that 1 or 1.5%, or they could be referring to the incredibly small percentage of that percent that occurs from 23 or 24 weeks to 28 weeks. Because if only 1.5% are after 21 weeks, I would say 75+% of those, and this is data that's incredibly hard to get because of how it's tracked, but I would venture to guess that 75%, maybe even up to 95% are before 24 weeks. That doesn't mean that you can't and nobody has abortions after 23 to 24 weeks, but the vast majority are going to be between that 21 and 24, 23 week point. And again, that's only 1% of all terminations in general. Okay. So when somebody is talking about late term abortion, do you mean all the post 21 week ones? Do you mean the 21 week to 24 week? Or do you mean the incredibly minute percent that happen after, colloquial viability, 23, 24 weeks, of which are almost exclusively because of lethal fetal anomalies or extreme danger that would prevent a safe delivery that would result in a baby that could go to the NICU. The reasons that you would do an abortion instead of a delivery after 25 or 26 weeks are just so incredibly few and far between. That almost never would be the case. I don't even know how to address this other than that people who use late-term abortion to further their cause probably themselves don't even have an accurate understanding of this. But if they do, and they're intentionally using this language to push their agenda, then that's certainly what the politicians are doing. Misinformation, as always. So we'll start with the Catholic Archdiocese of, is that how you say that? I don't know. We'll listen to misinformation number 1. And Karen says, note the manipulative music.
I want to start with an issue that it seems to me would be the most compelling reason for a person of goodwill who may not be so comfortable with abortion, but might feel compelled to vote yes on issue 1, and that's because of the issue of miscarriage care. So I'm going to read.
Okay, so first off, in addition to the manipulative music, I would note the manipulative language. A person of goodwill who otherwise might not agree with abortion but wants to make sure that miscarriage care is protected. So what they've already done is outlined that if you're a person of goodwill, you must also be not okay with abortion, and only voting yes on issue 1 because you're worried about miscarriage care. Now they're going to attempt to pretend that miscarriage care wouldn't be affected.
That's one of the misleading aspects of this amendment. No state in the country, including Ohio, restricts access to miscarriage care.
Lie.
So, God willing, if this amendment does not pass, miscarriage care will still be allowed in every hospital. And of course, we know Catholic hospitals do not perform abortions.
Okay, I don't even need to listen to any more of this, all right? So that is a lie. There are many ways that miscarriage care is affected by abortion restriction. We have already talked about misoprostol and mifepristone, which combined together are the most effective and reliable way to perform a first trimester abortion, but are also the preferred medications used for pregnancies which have a non-viable fetus, like no heartbeat, like a missed miscarriage, things like that. And the process is exactly the same. So when you restrict access to mifepristone, you increase the risk of somebody needing to have a surgical procedure when they have a miscarriage and need to be treated with medication. And that is a restriction on miscarriage care. Another way that this would be is if somebody is having a miscarriage, they are actively bleeding, they have a fetus that still has a heartbeat though. Okay, cervix is open, they're 8 weeks, they're bleeding, fetus still has a heartbeat. I can't, if miscarriage care is not protected along with abortion care, I can't intervene even though I know that this is going to result in a not viable pregnancy. I can't intervene unless there is extreme danger to this person's health because the fetus still has a heartbeat and that would be considered abortion, even though we know the cervix is dilated and this is not a pregnancy that can be saved. So I can't intervene in a miscarriage because of abortion restriction. So this is a lie. We'll see what League of Women Voters said.
When the 6-week ban was in effect, somebody made it into the national news. They were all over the news because they had traveled to Ohio. They were in the midst of a miscarriage. They were waiting for it to resolve. They traveled to attend a wedding and they almost bled to death because the hospital wouldn't give them would not treat them for their miscarriage because they the hospital felt uncomfortable because they didn't know that there wasn't fetal development, and they didn't feel comfortable saying that it wasn't viable because they didn't know.
Yeah, so that's exactly what I was saying. And then we've seen countless examples of this, people who have their water break at 18 weeks and they don't have the option to intervene until they are septic or until the fetus dies. And that doesn't mean that your water breaking at 18 weeks always results in the fetus not surviving. There are certainly cases where that's happened. I've taken care of patients myself where that's happened. But forcing people to put themselves in a position where they could suddenly become septic and die or lose their uterus is not something I think is ethical. And that is technically considered under the umbrella of a threatened or inevitable miscarriage at 18 weeks. So these are things we see frequently. People who have placenta previa and they start hemorrhaging at 18 weeks, but the baby's still alive at 18 weeks. You can't just deliver. That's still considered abortion. If I go in and deliver an 18-week fetus because it 100% will not survive that, that is still considered a pregnancy termination or an abortion under legislative umbrellas because the intention is to end a pregnancy where the fetus is currently alive and will not be alive after that procedure, no matter what that procedure is. And people want to claim that like inducing and delivering or doing a C-section and delivering at 18 weeks is not considered abortion. That's a lie. D&E, which is what they talk about where we do the procedure to dilate the cervix, and you've seen all the graphic images that people pass around and use as propaganda. That is a D&E, and that is one way that pregnancy termination happens at 18 or 20 weeks or 21 weeks or whatever, but it is not the only thing that is considered an abortion at that gestational age. All right, so they want to claim that it would remove parental consent for minors' abortions, which is not true.
The other key word in that line itself is the word individual. And nowhere in the amendment itself does it have the word woman. You'll hear a lot about protecting women's rights, protecting women's access to reproductive freedom, but nowhere in the amendment itself does it have the word woman.
Right, because it turns out that even if we don't want to be inclusive of trans and non-binary people, which I prefer to be, that there are children who get pregnant and are not women. So I don't understand, like, do you want to call a pregnant 10-year-old a woman? Or do you want to force a pregnant 10-year-old to carry a pregnancy? I think that's already clear based on David Yost's statements earlier that we talked about, but...
Using the word individual instead of woman, it can mean anyone. So a minor, a 15-year-old girl, could be able to access an abortion without their parents' knowledge or consent.
Why do you think this amendment would be harmful to women?
Of course, as Catholics, we believe that abortion does not help women.
Religion, that's why. That's your stance. I think this is harmful because I am Catholic. Okay, well, here is news for you. Some people are not Catholic. You already have your religious law, right? That's in your religious text, so it's not tracking.
Abortion is intentional killing of a human being, and that can never help women. But this amendment really goes farther, and that's where we've heard folks that would consider themselves pro-choice to be against this amendment.
Please do show me them. Show me where the pro-choice people who think that this amendment shouldn't pass are.
Ohio has a law that says that in order for a pregnant minor to obtain an abortion, she must get the consent of one parent, or she can go to court and get a ruling after a hearing.
Okay, yeah. So this is a common law in various states that you have to have permission from one of your guardians, or you can go and petition the court to let you do it without getting permission from your guardian, and you'll be at the mercy of the court. That's already going to be a difficult thing for a teen to do because, you know, they don't always have access to be able to do that. But what he's saying here is that this wouldn't remove that law, and that's how it is already, and that wouldn't be changed by this. Sneaking in gender-affirming care for minors. I'll ask Karen if we can get this put up somewhere on our website so that it's accessible and we can link it in the YouTube video when it goes up. And they're claiming that it would allow abortions up until the time of birth. And I just want to listen to this one quickly.
So proponents of issue 1 say that this is basically putting in place the provisions of Roe v. Wade, and that abortion would be legal in Ohio up to the point of fetal viability. But the Catholic Conference of Ohio said that this amendment would enable abortion.
She literally just said, I know that I read the legislation and it said it would be up until viability, but I did also hear some people who are religious saying that in their religious belief that that's not true.
So how is that the case?
But there are key words in the amendment itself that open the door to abortion at any time during a pregnancy. And those are when it references a woman's health.
I'm not going to let him talk anymore because he annoys me, actually. But in no case may such an abortion be prohibited if in the professional judgment of the pregnant patient's treating physician is necessary to protect the pregnant patient's life or health. So what he is saying here is actually what I think is that we should make it illegal for a doctor if they think that the person who's pregnant is in imminent danger of dying, that they shouldn't actually be able to like intervene in the way that they believe is medically the best option. So that is both ridiculous and irresponsible, and I'm not even going to let him keep speaking because that's so stupid. Doctors are not willy-nilly performing terminations on 36-week fetuses. And we've already talked about the fact that it's incredibly rare even after viability, and that I don't have any problem with this being the law because this would be such a rare event that it wouldn't matter. It would matter if you were the one person who fell into that category and the law said your doctor couldn't save your life, but it wouldn't matter on the grand scheme of things because none of us do this job because we want to go around doing 28 or 32 or 36 week terminations. It's just not how this works. It's not what we do. And leave the friggin' medicine to the doctors. And that's what this amendment does, is leaves the medicine to the people who are actually equipped to make the decisions. Do you see how these things kind of go together? Like, you put this in and then you say you're like, these people are claiming, oh, you shouldn't be able to let the doctors make that decision because, I don't know, we all just want to murder babies, apparently. But then when the laws are there and we don't do something, then we also get sued for being not able to make the right decisions. Like, it's a catch-22, and it's not fair to include that in legislation because blanket legislation always harms people, always harms people. Up until the moment of birth, this is ridiculous. Nobody is having elective terminations during birth. That's the dumbest thing I've ever heard. Infanticide, or killing a baby after it's born, is 100% illegal in every state. And any claims that that is not the case are just blatantly false. So what do the people want? Every single time that an issue of abortion has come to the ballot since Dobbs, voters have strongly supported access and choice. This makes sense because the general public, majority of people in the US, did not want Dobbs or the overturn of Roe v. Wade to happen. It has never been a majority opinion that Roe v. Wade should be overturned. That has never been the case, no matter what you have heard. No unbiased polls have been able to indicate that a majority of people wanted Roe v. Wade overturned. California, Michigan, Vermont, all of those states have voted to amend their constitutions to codify access to abortion. That is what this Ohio issue 1, voting yes on issue 1 would do. So it would put them with California, Michigan, and Vermont with codified access. Kentucky and Kansas were brought onto the ballot, an attempt to amend their state constitution specifically to say there is no inherent right to abortion, which would mean as soon as a federal ban went into place, that was it, no more. And their voters voted unequivocally, no, we do not want that put into the constitution of Kansas or Kentucky. Montana rejected the Born Alive Infant Protection Act, and that language is specifically chosen by extremist conservatives. So basically what they're saying is if a fetus is birthed and is, now we have this baby and it is alive, that we have to employ life-saving measures. Why is this a problematic thing? Because sometimes people come and deliver at 20 weeks or 21 weeks, and we know that the chances of a life-saving care happening in this are incredibly low. And forcing somebody, zero, 20-week fetuses that are born don't survive. They couldn't be alive when they're born, though. And I have had many patients who have delivered live borns at these gestational ages. But forcing somebody to employ futile, expensive, painful care to their child, which is not going to survive, is demonic. This comes into play at the 22 to 24 week gestational age too, because the chances of survival, particularly survival without incredibly life-limiting, expensive, painful problems, is much lower. So at that gestational age, it still needs to be a choice. People need to be able to choose if they would like comfort care or if they would like employing the, everything that we have available to us. And forcing people to do that is ridiculous. So they kind of frame this in it's in case they try to do an abortion and it doesn't work. But that's not a scenario that happens. That doesn't happen. And all that those kind of bills do is hurt people who are having already the worst day of their life. 58% of likely Ohio voters favor passing issue 1. So please, if you are in Ohio, vote yes on issue 1. Codify your right to access reproductive health care in your state. And thank you for listening. If you have been here the whole time, you are awesome. I'm going to hop off stream now because I have to go listen to some Taylor Swift, and I appreciate you being here. Thanks for being here. I'll see you next time. when I stream, or on YouTube, or on the second channel. Subscribe to the second channel. If you're new at MDJ Clips, this is my channel. Please don't report us for impersonating me or stealing my content. This is my second channel, and it's super secret, but don't turn us in, because